Good afternoon, everyone. My name is Anthony Davis. I'm the attorney that's going to be giving our presentation today. I'm with the law offices of Christopher Nudo. Today, our topic is going to be estate planning and children, protecting those that we love the most. So our focus is going to be if, God forbid, something were to happen to us as parents and we have minor children, kind of what plan do we have in place to make sure that, well, they're young and they're still growing up, that we've got a plan in place to make sure that they're taken care of, and we've got people lined up that have both the resources and the authority to step into that role. So again, my name is Anthony Davis. I'm an attorney with the law offices of Christopher S. Nudo. We specialize in wills, trusts, and estate planning. And there's the link to our website in the chat right there. So you can go check that out at your leisure. But we've been around for quite some time and we're specialists in this area. Here I've got a picture of our team as well as some of the organizations and awards that we've received. Before we get further into it, just a few housekeeping items. So if you guys could hold your questions until the end of the class, we have a lot of material that we're going to cover. When we get towards the end, you guys are going to have an opportunity to sign up for a free peace of mind planning session. And at that meeting, we can go over specific issues and specific questions, or just kind of review everything that we've talked about during this meeting. And you'll also have an opportunity to just ask me general questions as well at the end of the session. So there's going to be a Q&A. And so you just write down any questions that spring to mind during that. I've got an estate planning book that you guys should have received access to, and I'm going to go and just post that in the chat again as well. And you can just use that as a general resource to follow along with. You can also get that off of our website. So if you go there, there's a link that you can follow that'll allow you to sign up. You just put in your email and then that'll get sent to you. Just generally a good resource to have. General disclaimer. So this is for educational purposes. We're not going into specific situations for specific clients. We're just giving kind of a broad overview of everything. If you do want to have that more specific analysis of your family situation, just take advantage of that free peace of mind meeting at the end of the presentation, sign up for that, and then we can go over the specifics for your family. But this is just intended for just education, and it's not specific legal advice. Here I've got a picture of that PDF that I posted in the chat. So if you just check that out at your leisure, great reference. We're going to be going over a lot of material, and it's just kind of nice to have a textbook, a simple textbook that you can go back towards and just kind of refresh what all these legal terms mean and so forth. Just to let you guys know a little bit about our firm, we are a faith-based firm, so I'm not going to do any preaching, but there are a few things that I like to tease out from that I think are helpful for clients as far as kind of preparing themselves and their family for estate planning. So the first of those is I think it's a great idea to always have an aim or a goal in mind. That's a pretty good one. That tends to just snap everything into focus and make progressing towards that goal a lot easier. I also do think it's very important to focus on the experiences of people. We're estate planners. We're putting together a bunch of legal documents, but at the end of the day, it's going to be people that we're caring for, and it's going to be people that are actually executing the estate plan. So we want to keep in mind the experiences of both our loved ones that are going to be benefiting from this, as well as the experiences of our loved ones that are going to be actually carrying out and executing the plan. So we don't want to stay away from the emotion. The emotion is very important for this. In addition, I always like to encourage people to remember that as estate planners, it's easy to get wrapped up around finances and money, but money is important. Well, the finances are important. What really matters is, again, that experience of the family and the experience of the family that we're hoping to create if something tragic were to happen. And the money is a means to an end, but it's not the end itself. So, big question, kind of an important thing to go over, really basic, and it's kind of just who cares? Why does it matter? Why put together an estate plan? Isn't it just kind of turnkey? Everyone's just going to be logical and do the right thing. I've got a short video, a short clip that I like to play that kind of goes to that specific issue. And we'll talk about it afterwards. It's pretty entertaining, but I'm going to start it.
I figure 75% to you, Pon Ma, and 25% divided between the 5 of us. Yida, Crowbar, myself, Tom, and the baby. That makes 5% for each one of us.
Billy, you're cheating yourself. If there's 25% divided among the 5 of you, that's 14% apiece.
Oh, no, listen, Pa. I wouldn't cheat you. You know I wouldn't. Now, look here. I'll show you. Let me rub this out here. And now, 25 divided by 5 is 5. You see, 5 won't go into 2, will it? No. But 5 goes into 25 5 times, you see?
No, you're wrong, Billy. Now, I'm a pretty good mathematician. Now, 5 into 25... 5 won't go into 2, will it?
No.
But 5 goes into 5 once. Now, we didn't use the 2 before, so we bring it down here. Now, 5 into 20 goes 4 times. There you are. 5 into 25, 14.
No, look, Pa. Let me prove it to you now by multiplication. 5 times 5. 5 times 5 is 25.
Really, I'm surprised you're learning.
Huh?
I'm surprised that you're learning. Now I'll show you. 5 times 14 is 25. 5 times 4 is 20. 5 times 1 is 5. 25. That's it.
No, look, Ma. See, look, you're wrong there because I'll prove it to you. We'll put down 5 14s here. 14. There. Now I'll prove to you by addition that 5 14s is not 25. 4, 8, 12, 16, 20.
21, 22, 23, 24, 25. There you are. Better brush up, Billy. I don't want to see you boys cheated.
So that is just perfect. Basic math, you can't be any more logical than that, but everyone has a different movie playing in their head. And even something that seems as straightforward as mathematics, people can have all different kinds of perspectives of. Remember, we went over those 3 points: setting an aim, taking into account the emotional experiences, and remembering that we're focusing on people. Money matters, but we're focusing on people. People have emotions. They've got different things they're focusing on, different aims, different perspectives. And what we want to do with our estate plan is we want to just take away all of those different subjective viewpoints, and we just want to focus everything. We want to provide that roadmap, because oftentimes when you get right into it, it might seem like it's supposed to be common sense. People have different perspectives, and we don't want those perspectives to start making life more difficult for our loved ones. We want to take control of what the narrative is supposed to be for them if something happens to us. So when a loved one passes away, a lot of times, like I mentioned, there's a lot of emotion. People have different movies playing in their head, different perspectives. They may not necessarily be in the right state of mind. They're processing complex grief. That's just the reality of what happens when a loved one passes away. And again, that estate plan, it's an opportunity for us to make things a little bit easier for them, taking some of that burden off of them so they can focus on the tasks that they need to focus on, while also being able to kind of deal with their personal issues that are going on and not having it get in the way of the responsibilities that come up when somebody passes away. And that's important because if a person has the responsibility of taking care of children, if they're say a grandparent or a parent or a godparent that's been selected for that role, well, they may be processing that complex grief and going through all of that. The world doesn't stop. They still have responsibilities. They still have things that have to be taken care of, deadlines that have to be achieved, and their ability to access the tools that are going to be used. So their ability to access your estate, which provides them with the raw resources that they're going to want to use to take care of your children. The rules for accessing that change. So they're going through the emotional burden. The kids are going through the experiencing the emotional burden. Those selected guardians, agents, and trustees that are taking care of them are going through that emotional burden. And then at the same time, the rules, the processes, the bureaucracies for accessing your estate to take care of your kids, those change a little bit. And that's kind of a tough spot to be in. And you can kind of imagine it ends up being a bit of a negative feedback loop. If they're already going through the challenges of grief, and then they go to the bank and the bank starts telling them that if you want to have access to the funds to take care of the kids, you have to get something called a C. And banks do this. They'll just like throw out this weird legal language. And a lot of times they're kind of just reading off of a form or a pamphlet. They don't necessarily do a good job explaining things. That can be a little stressful. Sometimes they'll end up going to the bank. This is just different scenarios that have come up for me that I've experienced through practice. They'll go to the bank. The bank will end up freezing different accounts for the person that passed away. And that money might be essential to do things like pay the mortgage. And that's a challenge. They'll throw these weird legal terms like letters of office. Things like property taxes still have to be paid. And I know this seems like a common sense thing, of course, paying the property taxes, but then there's questions about who's responsible for doing that, how that's going to be paid. And then in addition, sometimes people just aren't in the best mental state of mind and they might forget to do that. And then at the same time, also, you've got credit card companies and other debtors that might be showing up to that person saying that they're supposed to be paid money. Are they or are they not supposed to be paid money? So what I kind of want you to get away from this is, again, estate planning might seem like something that's common sense and logical and it's just going to happen, but we really do need to take some time to take into account how exactly that this is going to be handled and how it's going to work, who should be having these roles, and we want to make sure that they're set up so that they already have a game plan in place that they can execute so that they can have everything move smoothly, while also taking into account their temperament, setting them up for where they might be mentally so that they can actually execute these roles successfully. Generally, I find that with my clients, if they're willing to ask these tough questions, and if they're willing to come together as a family and forthright, face those kinds of challenges, even now, even if they might be a little awkward, kind of face the tragedy of life, the possibility of that tragedy. If we do that, a lot of times through good estate planning, we can prevent the worst possible tragedies from occurring. If you pass away with minor children, you've got an estate, you've got think of it kind of like raw potentiality. You've got this estate, all of this stuff that you've spent your lifetime gathering up. That's an incredibly powerful resource. And if we provide some thought to it and have those tough questions and those tough conversations, we can set things up where if something were to happen to you, that estate can be safeguarded and transferred to your children and used for your children's welfare and protection. And that's kind of that high goal that we always want to have in place. We've got a lot of money that has to be preserved over a period of years, and we want to make sure that that money is being leveraged for the children's protection and that we're selecting the right people to do that. And if we do these things, if we have those conversations now, we can do a pretty good job of making sure that we've got something in place so that if something tragic happens, as tough as that's going to be, we can just proceed smoothly and the children's lives can be disrupted to the minimal extent necessary. We want to prevent disruption. So let's talk a little bit about specific minor children issues. So we hit why it is that this matters, and we've also hinted at kind of what are the two big issues that come up when we're doing estate planning for minor children. So the first of those, and you can kind of think of these as two broad categories to keep in mind. Who is it that we're going to want to have taking care of the kids? And who is it that we're going to want to have managing the inheritance? And how do we want the kids to receive the inheritance? So who's going to be taking care of them and managing the funds? And how are they going to receive those funds and how are they going to be managed? We always want to keep in mind who our potential guardians are going to be, and I'm going to go and translate these terms in a little bit. Guardians, loosely speaking, is going to be the person that has the authority to take care of the kids if something happens to both of you, who can be a guardian, and we want to make sure, this is most people's goals, to keep the kids out of the foster system. So kind of what conditions would cause them to go to the foster system. And then we want to give some mind as to at what age they should receive their inheritance. So are we okay with it being a flat age they receive it? Are we okay? Do we want it to be a staggered distribution? Do we have any concerns about potential debt or divorce, anything like that? And then are there any disabilities that the child might have that we should be given some thought to in making those distributions? So I brought up our two kind of major issues we're going to want to keep an eye on: who's going to be taking care of the kids and when it is that they're going to be receiving the estate funds, the inheritance. But let's go. I know I've been throwing some legalese out at you guys, and I apologize for that. But let me go and just kind of translate that, all of that weird legal language for you real quick, and then we can go back and apply it. So with estate planning, let's use a story to go through this. You start out in life. You go and you met your spouse, and life was pretty simple and pleasant. And then after that, it started to get more complicated. You started a family, had some kids, started gaining some stuff, the estate, started gaining some assets, that stuff. Life started to get a little bit more complicated. Life went on and it got even more complicated. The total size of the amount of stuff that you had grew and the types of assets became more complicated, a house perhaps. And then also maybe we added some more children to the family, or maybe we have a blended family. And then at a certain point, it occurred to you that maybe it would be a good idea to sit down with an attorney and start talking about this estate planning stuff. What happens if, God forbid, something were to happen to both myself and my spouse? How does my stuff end up going to my children, and how are my children protected and cared for? Well, when you sit down with that attorney is probably going to start throwing some buzzwords out at you. And that attorney is probably going to tell you that in the state of Illinois, when most people pass away, the estate goes through something called the probate court system. Probate is a court system that's very creditor focused. So the idea behind it is to make sure that any potential creditors know that someone has passed away so that they can attach to the estate and get paid the money that they're owed. And then after that's happened, then the estate can be distributed to whoever it is that you have set up to receive it. So with most families, this is going to be the children that they have. When you're talking with that attorney, you'll probably find out that probate doesn't have the best reputation, and this is due to the cost and time associated with it. In Illinois, you're looking at about 10 to 14 months. And the cost for a simple probate is usually about $7,500, $7,500 to $10,000 if it's not being contested and everything is pretty straightforward. You've also probably heard about something called a will, and I want to clarify real quick what a will does. So most estates go through that probate system. If you're okay with probate, if you're okay with the weight and the expense of the probate system, then you've probably also prepared something called a will, and a will goes with the probate system. So wills don't avoid probate. What they do is they tell the probate judge how it is that you wanted to have your stuff distributed. The next thing that most people will hear about, because um, a lot of times they're not really happy with the idea of the probate system, and they're not really interested in wills then at that point, is they'll done a little online research and learned about something called a trust. To make trust super simple and accessible, all that a trust is a big contract. So if I have a family that's decided to set up a trust, what they've done is they've decided that they do not want to have their estate go through that public probate system, and they want to have it where their estate is distributed through contract law. So they've prepared a contract that privately distributes the estate to the kids upon their passing, rather than going through that slow, cumbersome, expensive probate system. So that's probate, wills, and trust. So probate, long, slow, cumbersome court system. Will, document that goes with the probate and tells the probate judge how you want things distributed. Trust, contract that does not go through probate and allows the estate to be distributed immediately. When you're sitting down and talking with this attorney, he's probably going to mention to you, probably going to start talking to you about something called a guardian. What is a guardian and why would they be talking about that? Well, with minor children, if both spouses pass away, the question comes up, who's going to have authority to take care of those kids? The person that has that authority is called a guardian. And you can designate in estate planning documents who your chosen people to be guardians would be. So a couple things that are kind of important to remember about those guardian designations in any document. So let's say that we've got a trust and we've got grandma and grandpa designated as guardians. To kind of let you know how this works in the real world, them being designated in the trust as guardian does not immediately make them guardians. They still have to petition a court and be approved and appointed by the court. So why would we want to designate a guardian in these documents anyways? So it minimizes disputes over who should be the guardian. So let's say that you've got grandma and grandpa designated as guardian, but you've got some siblings who aren't designated as the guardian. If something happens to you, instead of having there be this kind of question as to who it is that is who should be guardian, you've already established in your document who your preference would be. And hopefully this heads off argument and unnecessary infighting that creates delays in having the kids taken care of and having someone appointed over them, because we want to have that guardian designated as soon as possible so we can avoid that foster system. Whoever it is that you select as the guardian is going to be weighed heavily by the judge. So the judge that's making the appointment is going to take very seriously the fact that, in our example, that you had selected grandma and grandpa as being the guardian. And most importantly, like I mentioned, by selecting that guardian, we're keeping the kids out of the foster system. And then over here, I've got a list of what goes, kind of the requirements for being designated as a guardian. The most important one that comes up occasionally is just being that U.S. citizen or permanent resident. So important thing to keep in mind a lot of times with my immigrant family clients, the people that they necessarily want to have as guardian may not have U.S. citizen or permanent resident status. So something to give some thought to. About selecting that guardian, in estate planning practice, I've continually had it happen, and we always want to avoid this, is we'll go over these roles with the client, and the client will select people that they kind of know, but they don't give too much thought to that designation. We want to keep in mind that whoever it is that we're selecting as a guardian, want to be sensitive to the emotional experiences of the people that our documents impact. Whoever it is that we're selecting as our guardian, if they take on that role, they are taking on a job. They are taking on a full-time, life-changing job. And we want to make sure, we want to give some real careful thought to this, that those people have qualities that are going to be really good for those kids. We want to make sure that they have qualities where they're going to provide the guidance, the parenting, and that they're going to have the energy to carry out this task. We don't want them to get into it and then realize that it's too much. So we want to give some careful thought to the personalities, age, and experiences and general suitability of the guardian. And I strongly suggest talking to those people before putting them into the document. Okay, so those are our guardianship concerns. The next thing that is important is what age do we want our kids to receive an inheritance? So that might seem like kind of a no-brainer. Default age for most asset types in Illinois is going to be 18. There's a few exceptions to that where the minor children would receive the asset at 21. But for the most part, we can kind of think of it as the default answer to this question, unless we step in and modify it through our trust instrument, is going to be age 18. As you can imagine, though, many parents, I would say something like 99% at least of the clients I work with, they're pretty unhappy with the idea of their children receiving their full inheritance at age 18. I mean, if you just kind of think back to how mature you were at that age, not necessarily making the best decisions, not necessarily thinking long term. We all think we're going to live forever. And a lot of times parents want to have some control over when and how those funds, which can be quite large, are going to be used. This is one of those things where we want to have those careful conversations with our spouse. We want to take into account, to the best that we're able to, what our child's future temperament is going to be. Some kids you can give $1 million to at age 18 and they're going to be super great with it. Vast majority of kids need to have some time to mature, but we need to give some thought based on what we know about our children as to, and ourselves and the environment that they're in, as to what age we think they're going to become good custodians of money. So how do we do this in the real world? Well, a lot of times, if I have a client that doesn't want their kids to receive everything outright at 18, we'll just stagger the inheritance. So let me kind of lay out for you how this works in the real world. So let's say that you come in and we set up that trust contract with you. And that trust contract, you tell me that we've got our guardian designated, and you tell me that you do not want your child to receive the entirety of your, let's say, $4 million estate at age 18. You want to have those distributions staggered and controlled. Well, what we're going to do is we're going to put language in that trust contract, and that trust contract is going to designate somebody called a successor trustee. So in our trust, we've got you, who's the contract creator, and we're also going to designate somebody where after both you and your wife and your spouse pass away, that person is going to step up and they're going to be responsible for all of the estate assets and shepherding them and safeguarding them and distributing them according to the terms of the contract to your child. That person is the successor trustee. So that person, we're going to designate in our trust contract who our successor trustee is, and our contract is going to tell them that what we want them to do if we both pass away is to go to a bank, go to the IRS, and we want them to get a tax EIN number and open up a separate trust account at the bank for that child. So we've got our trust contract and we've got a trust account at the bank. And then in our trust contract, we're going to have certain ages and percentages where we want that child to receive a distribution. So common examples would be when that child turns age 25, they can take 10% of that 4 million. At age 30, 30%, age 35, 30%, and then at age 40, the balance. It doesn't have to be these ages and percentages. We can change those, but that's generally the gist of it. So trust contract designates successor trustee. Successor trustee opens up trust account and then is distributing funds according to the schedule laid out in the trust contract. So you probably have a few questions about how that plays out. So what we typically do with clients is we want to make sure, because if we're going to have these staggered distributions, we have to have something to distribute. So we have to have some money in that trust account, right? So what we're typically going to do is we're going to suggest to the client that what they should do is go to their liquid accounts, so bank accounts, retirement accounts, and insurance, and designate the trust as being at least what's called a contingent beneficiary. So what that means is, in our scenario, if my two clients pass away, God forbid, their bank accounts, retirement accounts, and insurance have the trust listed as being the beneficiary. Our successor trustee can go to those institutions with a death certificate, and those institutions will pay out. Let's say we've got a bank account with $500,000 in it. If we've got the trust set as the beneficiary, that $500,000 will pay into the trust account. Okay, does that make sense? So by setting beneficiaries where the trust is the contingent beneficiary, then upon something happened to both of you, that trust account, everything flows into that trust account. And now we have a whole lot of money in there that can be used over the life of the child to take care of them, and can also be used to make these distributions at these age points. That successor trustee, let's say that our minor child is 4 years old at the time that both of you pass away. Our successor trustee has a fiduciary duty to make distributions from that trust account for the health, education, maintenance, and support of your child. That's called a HEM standard. And then at those age points, say age 25, then the child can request to have 10% distributed to them. And we make it where the child makes the request, because that way, if they're going through a divorce or if they have creditor problems in that year, they can put off receiving that let's say 10% until after that threat has passed. So just to recap that before we go to powers of attorney, you can control the distribution schedule for your children. You can make it where there's a trust account for them, where the entirety of your estate flows into this trust account, and then the funds are used over a period of years to take care of them. And you can also set guardians, your preference for guardians. So we can set the people that we want to have take care of the kids, and we can control the distributions of the funds to them. One other document type that's very important when we're planning for families with minor children are something called powers of attorney. So what is a power of attorney? It's something called a living document. So that means it only functions while you're alive. After you pass away, it ceases to do anything. With a power of attorney, what we're doing is we're designating an agent. So this is going to be your chosen person who has the authority to make healthcare and financial decisions for you when you're too sick to do those on your own. Typically, the spouse is going to be our first agent, and then we're going to have some backups. The reason we care about this is that if you've got minor children, and let's say both you and your spouse get sick, or one of you passes away and the survivor is sick, we want to make sure that we have people in line that while you're not well, while you're perhaps getting better, while you're out of the picture, we want to make sure that we have somebody in place that can get into your accounts and access funds so that they can use that money for your kids. We want to prevent a disruption of their life. So normally in estate planning, when we talk about powers of attorney, we're thinking in terms of making sure that you, the parents, are going to be protected. That's important as well. But in particular with minor children, super, super, super important to make sure that if both of you get sick, somebody's in place that can access your accounts so that they can do things like pay up carrying costs on the house, pay tuition. They can make sure that the children's lives are not going to be disrupted in that manner by your illness. When we're designating that agent, okay, that person, we're kind of looking, think of it like we're looking for a superhero. So again, this is the same set of important things to take into account, like when we went and wanted to think about our guardian. These people are getting a real job. If you're designated as an agent on powers of attorney, that's a job. If you're listed as successor trustee and you're managing those estate finances for 10 to 15 years, that's a job. If you're listed as a guardian, that's a job. And we want to take into account the competencies and temperaments of those people that we're selecting so that when they step into that role, when they take on that superhero role, that they're competent and motivated and ready, and it's not a surprise. That's very important. A lot of times people will do this where they'll go and meet the lawyer will ask them for some names, and then they'll just put down 3 people that they think will be good, and those 3 people have no idea that they're on that document, and then it ends up being quite the surprise when they have to step into that role, and they may not be ready or willing to do that. So talk with those loved ones, have those tough conversations now, make sure that we're setting them up so that they can fulfill those roles. So a few final tips and final tips and takeaways. We want to make sure in those roles, the guardian, trustee, the agent, that we're selecting people that we feel we can trust with our children. We want to take into account the timing of inheritance. We don't want it to be where an 18-year-old child is receiving hundreds of thousands or millions of dollars and then just using those funds in an inappropriate or destructive manner to themselves. We want to have a plan in place because as tough as these conversations are, if something, God forbid, happens to us, we've got that combination of needing to get into accounts, needing to gain access, life goes on, needing to take care of these responsibilities that pop up, and then also dealing with the emotional burden that comes with the loss of a loved one. So we want to take at least part of that stress away and give them a solid plan that they can follow that kind of automates at least a little bit of the process. And we always want to talk with our family. We want to have those conversations to make sure everyone has the same movie playing in their head. So what's the next step before our Q&A? Well, you can schedule a free peace of mind planning session. And I'm going to go and post the link for that right now. All right, so I just posted that in the chat. If you go and click on that, it'll take you to a Microsoft bookings list, and then you can go and you can pick a time there. I know that we went over quite a bit during this meeting. Hopefully it didn't feel too much like drinking from a fire hose, but that's an opportunity for me to kind of review this in a more intimate setting and also get a more clear idea about your family. And we do offer both virtual as well as in-person meetings. So we can meet over Microsoft Teams, or we could meet in person at either our Rolling Meadows or Elgin office. We do focus on your goals. I feel strongly that setting goals is important in any kind of estate planning. And if you decide to work with us, that's great. If not, we just part as friends. And like I said before, we have those offices in both Rolling Meadows and Elgin. In Rolling Meadows, this is our address, 3601 West Algonquin Road, Suite 860. We're that big gold building. And then we also have an office in Elgin at 1250 Larkin. It's right by the high school. So now it's time for the Q&A. I've got my information over here with my phone number, email anthony@nudo.net, as well as, again, the website, www.nudo.net. So if you want to reach me, that's how you would reach me. But if you've got any questions, just post them in the chat right now, and I'll be happy to answer them.